Arispe, come up. You now have picked up a new case, Mr. Arispe. You now stand charged with terroristic threat or a family or a household member. We are going to do probable cause. You
Officer was dispatched to a residence in response to a family disturbance. The complainant, the defendant's stepmother, stated that the defendant was upset because he was owed money. The defendant told other members of the complainant's family, if they don't have my money by tonight, I'm going to kill them, as well as I'm going to send my people to shoot them up. The defendant also told the complainant directly, if you don't have my money by tonight, you are going to see. A family member of the defendant and complainant stated that he had seen the defendant walking around with a pistol in his pocket. And the complainant knows that the defendant owned several rifles as well.
You were on bond for unlawful carrying of a weapon. Did we order him not to have one?
Yes, Judge.
Regardless, you've picked up a new case. What happens now is I'm going to revoke your bond in the first place and you will stay with me. I will appoint you a lawyer today, Mr. Arispe, so we can talk about how to go forward, but I am ordering you now not to have any contact with these people. Do you understand?
Sir.
And I'm going to tell you, you pick up a third case, I'm going to go bonkers on the bonds. Do you understand?
Sir.
I'm going to do everything in my power to protect this public at all cost. All right, goes with you. Do you mind appointing him? No? Yeah, when we get a lawyer. We'll do it.
Mr. Nguyen, in cause number 25 DCCR 0750, you're charged with the second-degree felony offense of burglary of a habitation from April 29th of 2025. And how do you plead to that charge? I'm sorry? And it looks like the agreement that you reached is for an 8-year deferred probation. There would be a $500 fine, and you would be required to follow all of the rules and conditions of probation. Do you understand? All right, sir, I'm going to find that you entered your plea of guilty freely and voluntarily. Find sufficient evidence to find you guilty. However, I'm going to reset your case for sentencing so that the probation department can do a pre-sentence report. That'll give me more information about you and your case, and then we'll come back later for sentencing. Mr. Nichols, what's the state's position with regard to bond reduction?
There's quite a few misdemeanors, Your Honor, for burglary of vehicle and trespass, among a couple other things. We don't see any other felony cases. This burglary is against property owned by his mother. I don't believe it was her residence. I believe it was a place she owned. He went there and essentially stole TV. So I do have some concerns, but his criminal history is not particularly extensive, Your Honor.
Just sounds like it's some of the same things, though, that I have some.
Correct. It's mostly burglary, several burglary vehicle charges, several trespass charges.
All right, I'm not going to adjust the bond at this time, just in case I want to do something up front based on that misdemeanor history. All right, we'll get the pre-sentence report, and then you'll get sentenced at the next court date. You can go back with the bailiff.
Thank you, Your Honor.
Thank you.
Judge, just so the court knows, because he was just asking, it looks, there's almost all of those misdemeanors are from about 15 years ago, except for a trespass last year.
Okay, come
So I just
back.
wanted to make the court aware of that.
All right, so here's what I'm going to do. Mr. Nguyen, I am going to reduce your bond in your case based on your plea agreement to $1,000. If you make that bond, a condition of it at this time is that you have no contact with your mom. Okay, you cannot go near her, any of her properties. Do you have a place to live? With your brother? Okay, so now there may be a time when you can have contact, but at this point, because she's the victim in this offense, you are to have no contact, no communication. Obviously, that means in person, but it also means sending messages or text or anything like that. Do you understand? And what'll happen if you make that bond is the very first thing you need to do is go straight to the probation department so that they can do that pre-sentence report. If you don't do that, then you run the risk of me not accepting the plea agreement. Things could be worse. Do you understand? Okay, you can go back with the bailiff.
Viharo, come up. Oh, does he speak? You speak English? You were charged with this DWI, and in this DWI, we have a dead body, right?
Yes, sir.
Now, Mr. Viharo has bond violations. And in this violation report, I have here that you are consuming alcohol and that you're going out in the middle of the night. Am I wrong?
Well, on the GPS issue, Judge, I mean, he left 2 minutes before he was heading to work, 2 minutes prior to.
Okay.
To.
Well, I'm not going to ding someone for going to work, but
Sure.
if you're consuming alcohol, I have a real problem with
And
it.
then that's why we're here. And I've, he's been on conditions since April and there's no excuse, made a terrible decision. I have been on him since I found out about this last week.
I get it, but when I have a dead body, I have a real problem with that. And I can't just let it go unnoticed. It's unacceptable. I'm sorry, counsel, but I'm not going to let you go. You stay with me. I'm now going to revoke your bond. I mean, do you, anything you wanted to add?
Nothing, Judge, just. We'll get
Steph? Yeah, no. All right, let's do the switch. It's unacceptable. I told you there was absolutely no tolerance. I have here that you're consuming alcohol. You need to know. No, you'll stay with me now. I'm revoking your bond. The bond is set at what?
It was $100.
Yeah, all right, 5,001.
You're Vonzell Hall, correct? And will your client waive the formal reading of the indictment?
Yes, Your Honor.
Charged with the first-degree felony offense of murder, and that is from August 10th of 2024. How do you plead to that charge? Are you pleading guilty freely and voluntarily? And are you pleading guilty because you did what they charged you with? I have here on the computer some documents that have your signature on them that the state has marked as exhibit number 1. And do you understand, if I follow the agreement that you made with the district attorney, that you'll be waiving or giving up any right to appeal? And it looks like y'all have decided not on the cap, but on the.
That's correct, Your
Okay.
Honor. And despite what he said earlier, we changed our mind to
Okay.
the original 35.
All right, sir, I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of your plea. Find sufficient evidence to find you guilty, and at this time, find you guilty of murder. Sentence you in accordance with your agreement to a term of 35 years in the Institutional Division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. You also should thank Mr. Matuska because he worked out an excellent deal for you on this type of case, and I can assure you if you had gone with the cap, things would have been a little bit worse. Do you understand? Go back with the bailiff.
Good morning, Judge. I'm here on Emma Lynch. She's got a bond violation. You wanted to talk to her.
Okay, do you mind bringing her up?
Yes, Miss Lynch. When we were here last time, you ordered her to have the interlock installed on her vehicle. She is not driving the vehicle. It's not drivable. We just need to switch her to a portable.
Oh, no.
And a no driver.
She has nothing. And it doesn't matter. We ordered you to have an interlock in a car. You haven't done anything and you're without any kind of devices whatsoever, right?
That was totaled and it's at my house right now, but I don't have I'm in a rental car that I'm not driving, so I don't have a car to put it in.
So you have no device.
That's correct.
You're not being monitored.
That's correct.
This is not a good thing, Miss Lynch, because I ordered you to have a device. And from what I understand here, you never even went and got it.
It's because she doesn't have a vehicle to put it on.
But you come back and you say, hey, Judge, I don't have a vehicle. I need to do something else. You just don't, out of sight, out of mind. That's not the way things work.
Judge, for that violation as well, we instructed her in court and sent a message for her to report to 49 following court to get further instruction over everything so that we could figure out things from there, and she never reported.
Stephen. Miss Lynch, you haven't done anything. They've literally bent over backwards to help you and do stuff, and you haven't done anything.
I wanted to come in today.
The only reason you're here today is because I ordered you here
Yes,
today.
sir. Yes, sir.
She goes with you.
Yes, sir.
Emailed, texted, call, nothing. You know,
I understand. Would you consider setting her a new bond or do you?
of course, 5,001. And then, you know, if she's unable to, then what's today, Friday, Monday, then we can talk. Okay?
It makes me stop.
Yes, ma'am.
Mr. Garner, you're charged with the second-degree felony offense of robbery. And how do you plead to that charge?
Guilty.
You're charged with the third-degree felony offense of obstruction or retaliation from June 3rd of 2025. And how do you plead to that charge?
Guilty.
For DCCR 2324, you're charged with the second-degree felony offense of indecency with a child by contact, 5th of 2019. And how do you plead to that charge? Guilty. And then finally, in 24 DCCR 2324, that's the indecency case, I have here a sex offender registration requirement form that looks like it has your signature with Mr. Matuska's. You understand that as a result of this plea, you will be required to register as a sex offender, right? All right, sir, I'm going to find in all three of your cases that you entered your pleas of guilty freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of those pleas. Find sufficient evidence to find you guilty, and at this time find you guilty of the second-degree felony offense of robbery. Sentence you in accordance with your agreement to a term of 10 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. So find sufficient evidence to find you guilty, and at this time find you guilty of the third-degree felony offense of obstruction or retaliation. Sentence you in accordance with your agreement to a term of 10 years in the institutional division of the Texas Department of Corrections. You will also receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. Find sufficient evidence to find you guilty, and at this time find you guilty of indecent child by sexual contact. Sentence you in accordance with your agreement to a term of 10 years in the institutional division of the Texas Department of Corrections. You will also receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. These three cases will run concurrently, which means together at the same time. Because of the judgments entered against you, you're ineligible under Texas law to possess a firearm or ammunition, Mr. Matuska, right? Good luck to you, sir. You can go back with the bailiff.
If you are new to my channel, please subscribe as I edit these cases and remove all of the mundane, boring, repetitive stuff. And I even remove the silences, so you get only the juicy bits, which I think are always the best bits. Are looking for another episode that has all the boring stuff cut out and gives you just the good stuff, then here a couple that may interest you. Enjoy.